first lecture of the semester, Introduction to Criminal Law. In this lecture, we're going to cover the first of 3 topics in the Foundations of Criminal Law module. My basic goal for this lecture is simple. I want to give you a better sense of what the criminal law is about. As you listen to the lecture, keep in mind that most of the ideas covered here will come up again in future classes. So if you walk away from the lecture wanting to know more, that's great, because a lot more information is on the way. So there are 3 main learning objectives for today's lecture. First, I'm going to provide you with a basic understanding of what criminal law is and how it differs from the civil law. Second, I'm going to discuss the relationship between criminal law and criminal procedure. Third, I'm going to briefly introduce you to the structure and sources of the criminal law. So without further ado, let's dive in. Okay, this is a class about substantive criminal law. But what's that? Well, defining what the criminal law is turns out to be a surprisingly difficult task, as we'll explore together in class. For now, we can say that the substantive criminal law is the study of offenses committed against society. The idea is like this. Typically, someone who violates the criminal law has engaged in morally wrongful conduct. And that conduct has serious consequences which go beyond the harm suffered by any particular victim. So people who commit crimes need to make amends with both victims and society at large. In general, criminal offenses speak to the worst harms imaginable. We're talking about things like taking a human life, causing serious bodily injury, and violating someone's sexual autonomy. This kind of conduct can destroy the lives of victims, and it can also cause severe emotional damage to victims' families, friends, and communities. Take a moment to imagine being told about a gruesome crime being perpetrated against someone in your community. Now, you don't know this person, but you know this person could have just as easily been you. How do you think hearing about this crime would make you feel? Pretty terrible, right? Yeah, you don't need to know a victim to feel a deep sense of sadness and injustice for their suffering. And a crime doesn't have to happen next door for you to worry that the same thing could happen to you. If society exists to promote freedom and happiness, then the fear and sense of injustice associated with crime threatens the very foundation of communal living. That's one reason why we tend to view people who commit crimes as uniquely culpable or blameworthy for what they've done. And that's also why we tend to think that particularly harsh consequences, that is, punishment, is an appropriate way to deal with culpable conduct. This helps us understand why the criminal law is distinct from civil law. In torts, injured parties can hire private attorneys to help them seek money damages from the person who caused their injuries. But the injured party can also decline to bring a lawsuit for compensation. And even where the injured party gets compensation, the tortfeasor gets to stay in the community with their freedom intact. By contrast, crimes in the United States are not brought by privately hired attorneys who represent individual victims. Instead, they're brought by public attorneys, known as prosecutors, who represent the community as a whole. So prosecutors will often take the views of individual victims into account before bringing a case. But importantly, those views are not determinative. Unlike civil cases, prosecutors also typically seek more than money from criminal defendants. Although someone convicted of a crime may be ordered to pay a fine or restitution, the touchstone of criminal prosecutions is the imposition of punishment, most often incarceration. So many people think then that punishment, and incarceration in particular, is the criminal law's defining feature. We'll explore whether that's true in class, but for now, I want to simply point out that people convicted of crimes are not always incarcerated. For example, a first-time offender convicted of simple assault, that is, intentionally causing bodily injury to another person, may very well avoid being sentenced to any jail or prison time. But that doesn't mean there aren't differences between criminal and civil assault liability. Arguably, being labeled a criminal carries with it a societal stigma that being labeled a tortfeasor doesn't. And that's true even if both parties were convicted of the same kind of assaultive conduct. Aside from social stigma, there are also many important collateral consequences that only follow from being convicted of a crime. These include things like restrictions on voting, public benefits, and gun rights. Because of these serious consequences, the stakes are uniquely high in the criminal law. And with these high stakes come special procedural protections in criminal cases. This is reflected in the constitutional right to a jury trial. Specifically, the Sixth Amendment to the U.S. Constitution provides that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. This right applies to all prosecutions involving more than 6 months of incarceration. And in most places, juries of 12 need to reach unanimous verdicts. The U.S. Constitution also requires that a criminal jury always be impartial, drawn from a fair cross-section of the community. Another special procedural protection is reflected in what's called the burden of proof. In civil law, the party bringing the suit has to prove the wrongful injury by a standard known as the preponderance of the evidence. In plain English, this basically means more likely than not. By contrast, in the criminal law, the prosecution has to prove every element of an offense beyond a reasonable doubt. That requirement's rooted in the 5th and 14th Amendments, which state that no person shall be deprived of life, liberty, or property without due process of law. As we'll discuss in more detail, proof beyond a reasonable doubt, or what I'll sometimes refer to as PBARD, doesn't mean proof beyond any conceivable doubt. That's beyond human capacity to say in most cases. But before punishment's imposed, the criminal system does require a very high level of certainty. As the U.S. Supreme Court stated in Jackson v. Virginia, proof beyond a reasonable doubt requires a subjective state of near certitude of guilt. The In re Winship case assigned in your reading focuses on the requirement of proof beyond a reasonable doubt. We'll spend time discussing this case and the PBARD standard during our first class. But aside from the PBARD standard, we'll spend very little time this semester discussing criminal procedure, which is to say, the processes by which a criminal case works its way through the criminal legal system. In one sense, that's good news, because as you'll come to see this semester, learning how to read, interpret, and apply criminal statutes is already pretty challenging. Add criminal procedure to the mix, and some brains might explode. On the other hand, criminal procedure is a really important part of understanding how society deals with crime, and to making sense of who ends up in prison and why. So, while you're not responsible for the topic, it's helpful to know a little bit about the role that both criminal law and criminal procedure play in the larger criminal legal system. One way to do that is with a thought experiment. I want you to imagine that you're tasked with creating a criminal legal system from the ground up. What would you need to do to make that happen? Here's one way to think about it. First, you need to figure out the system's rules of conduct. That is, the don'ts, the do's, and the consequences for violating these prohibitions. That's substantive criminal law in a nutshell. And it's the foundation of a criminal system. But ultimately, it's just one small piece of a much bigger operation. Let me give you an example. To enforce the criminal law, you need to establish a government team dedicated to detecting violations and, when it's appropriate, arresting violators. That's the police. And because the power to police is incredibly dangerous, you would also need to create an extensive body of rules to ensure that police investigations are completed fairly, effectively, and efficiently. These rules are what the first class on criminal procedure covers. All things relevant to the relationship between police and people. Now, to enforce rule violations, the next thing you need is a government team dedicated to proving that violations occurred and, where appropriate, arguing for appropriate sanctions. Those are prosecutors. Then, those charged with violations would need attorneys on their side, either private or public, to help them defend against prosecutions and to help them strike bargains, which are otherwise known as plea deals. Those are defense attorneys. Then, you would also need to create a government team of neutral parties to adjudicate disputes between police, prosecutors, and defense attorneys. Those are trial judges. And because multiple community perspectives are arguably better than a single judicial perspective, you would need representative bodies drawn from the community to determine whether violations of the criminal law have occurred. Those are juries. And again, because of human infallibility and how high the criminal law stakes are, you would want to create additional layers of judicial review to ensure that trial judges and juries don't make serious material errors. Those are appellate courts. Finally, and perhaps most important, you need to create an extensive body of rules to ensure that all of these post-arrest legal interactions, from charging to trial to sentencing to appeal, are done fairly, effectively, and efficiently. These rules are what the second class on criminal procedure covers, from bail to jail, as law professors often say. So much, then, of what happens in the criminal legal system is about process, rather than the content of our criminal laws. But it's also about the people who are part of the process and the decisions those people make. Arguably, the most important word in the criminal legal system is discretion, because discretion pervades the system and plays a huge role in how it operates and who it affects. For one thing, victims possess the discretion to report crimes to law enforcement, and many don't. In the real world, only about half of all violent crimes and a third of property crimes are ever reported by anyone. And of those crimes that are reported, an even smaller number will be investigated by the police to the point of making an arrest. Then, an even smaller number from there will proceed to the point of prosecution. It's hard to overstate the point. Police and prosecutors have incredible discretion regarding who to arrest and who to charge. There are many reasons why an arrest might never be made or why a case might never be brought. For example, law enforcement might not have the resources to devote to making an arrest or to bring charges. Or they might lack access to the kind of evidence necessary to make an arrest or establish guilt. And of course, there are many illegitimate reasons why some arrests and prosecutions happen, yet others don't. These include racism, corruption, and sheer incompetence. Even where a prosecution happens, it remains very rare that a trial will follow. Although rates vary by jurisdiction, more than 90% of cases are generally resolved through what I previously described as a plea bargain. Basically, a prosecutor uses their discretion to either dismiss charges, reduce the severity of a charge, or recommend a more lenient sentence after conviction in exchange for a criminal defendant's willingness to plead guilty. In the event a case goes to trial, juries can use their discretion to disregard the law and render a verdict contrary to it. This controversial practice is known as jury nullification. Finally, whether a defendant is convicted at trial or by plea, judges typically exercise tremendous discretion in determining the amount of incarceration that should be imposed, or whether incarceration should be imposed at all. As I hope this presentation has made clear, the criminal law is but one small piece of a much bigger criminal system where procedural rules and discretionary decisions have a huge influence. And yet, at the same time, the criminal law remains an important and unavoidable piece of that system. Each of the millions of people who wake up in a US prison or jail every morning were convicted of violating a criminal law. And without that criminal law, their lives would look very different. As a result, it's important to carefully study and understand what criminal offenses mean and how they're interpreted by legal actors. As you'll see throughout the semester, the basic unit of analysis in our class will be a criminal offenses elements. These elements are the basic requirements that the government has to prove beyond a reasonable doubt in order to secure a criminal conviction. The two most central elements of every offense are its social harm, or actus reus, and the guilty mind, or mens rea. Typically, people think of crimes in terms of their actus reus. For example, we speak of violent offenses like assault and murder, property crimes like theft and fraud, and drug offenses like distribution and possession. Sometimes it'll be obvious what the social harm of an offense is. For example, no one questions whether killing or maiming is harmful. But in other instances, like the case of drug possession, an offense's social harm might be less clear. Even still, the social harm is the most observable and intuitive aspect of a crime. And yet, to commit a crime is not just to do a bad thing. In most cases, harmful conduct becomes criminal only when it's accompanied by a blameworthy state of mind. So for example, murder is defined as intentionally killing, theft as taking with the intent to permanently deprive, and assault as the reckless infliction of bodily injury. These mental state requirements exist because the criminal legal system generally doesn't punish people who make reasonable mistakes, who engage in unavoidable accidents, or who can't think or act morally, say because they're suffering from mental illness, when they violate criminal prohibitions. The individuals in these situations may have done something harmful, perhaps terribly so, but in the absence of a guilty mind, the law typically views them as morally innocent and thus beyond the reach of criminal liability. We're going to go more deeply into the elements of liability during the second module. For now, I just want to say a few words about where they can be found. Historically, a lot of criminal law was made up by judges through common law. But today, at least in general, most crimes are codified by statutes, which are written by legislatures. Every state has its own set of crimes, and so does the federal system. Crimes are compiled in criminal codes, which are divided into two sections. The first section is referred to as the general part. It's filled with general principles of criminal responsibility, rules of interpretation, and definitions. The second section of a criminal code is referred to as the special part. It primarily includes offense definitions. The provisions in the general part of a criminal code help us understand the meaning and application of the offense definitions contained in a criminal code special part. To illustrate, let's take a look at a couple of provisions in the California Penal Code. The first is California's general provision on intoxication, which is contained in the code's general part. Specifically, California Penal Code Section 29A states that no act committed by a person while in a state of voluntary intoxication is less criminal by reason of his or her having been in that condition. Now consider the California offense of mayhem, which is contained in the code's special part. Specifically, California Penal Code Section 203 states that every person who unlawfully and maliciously deprives a human being of a member of his body, or disables, disfigures, or renders it useless, or cuts or disables the tongue, or puts out an eye, or slits the nose, ear, or lip, is guilty of mayhem. Now, consider the following situation. You intentionally get very drunk and then decide to cut off my arm. Ouch! Applying the California general provision on intoxication to the specific definition of mayhem suggests that you're voluntarily being intoxicated doesn't make your decapitation of my arm any less criminal for you or more enjoyable for me. But legislatively stating this principle in a general provision does make it more enjoyable, or at least easier, for courts to resolve this type of issue when it arises in the context of a mayhem prosecution, or any other prosecution for that matter. As we'll learn in the third part of this module, this is because any policy issue that isn't resolved by the legislature will ultimately need to be resolved by the courts. And there are many problems with courts serving in this policymaking role, particularly in the context of criminal law. But for now, you can put those problems aside and celebrate the fact that you've almost made it to the end of the first lecture in this class. Before we sign off, there are 4 key criminal terms I'd like to clarify the meaning of: prison, jail, felony, and misdemeanor. Turn on the news, and you'll almost surely hear the words prison and jail being used as though they mean the same thing. But that's a mistake. Although both institutions are used to incarcerate, there are important distinctions between them. Generally speaking, a jail is a local holding facility under the jurisdiction of a city, local district, or county. People who are newly arrested, awaiting trial, or awaiting sentencing are typically held there. In addition, jails also house those who have been sentenced to serve less than a year of incarceration. By contrast, people who are sentenced to more than a year of incarceration are sent to prisons. Basically, a prison is an institutional facility under the jurisdiction of the state or federal government where convicted offenders serve longer sentences. This institutional distinction between jail and prison helps us understand an important distinction in criminal classifications. So look, crimes come in all shapes and sizes, but there are 2 major categories. The first is a misdemeanor. Generally speaking, a misdemeanor is an offense for which the maximum punishment is a monetary fine, short-term incarceration in a local jail, or both. By contrast, more severe crimes are typically classified as felonies. Generally speaking, a felony is an offense that is either punishable by death or any length of incarceration in a state or federal prison. In this class, we'll spend most of our time focusing on felonies. But as the Natapov reading you were assigned reveals, misdemeanors represent about 80% of the state criminal docket. And they are a very important part of how the criminal legal system in the United States operates. You've reached the end of our first lecture. Congratulations! It's now time to do the reading and complete the class assignments for the first topic, Introducing Criminal Law. Thanks.